area. So I implore everyone to participate fully, avail yourselves of the opportunity to glean all the knowledge you can glean. And again, thank you, Wedderburn, for being with us this evening to enlighten all of us. Thank you.
Thank you for having me.
Thank you, Costas. Thank you for that. I'm going to ask Ms. LaShawn to introduce our guest speaker. And for persons that, so we are at 157, and our platform can take 300, but we are putting a contingency plan, Ms. Wedderburn, just in case persons cannot get on. We have a live stream, so persons can get onto that. So as soon as we see that we are going to pass that mark, we'll send that out. LaShawn?
Good evening, fellow justices. Miss Julia Wedderburn is the Senior Director of Legal Education at the Ministry of Justice and Constitutional Affairs. She's an attorney at law who was called to the Jamaican bar in 2012. She has a Bachelor of Education from the University of the West Indies, a Bachelor of Laws from the University of London, and a Master of Laws in Public Law from the University of the West Indies. She has over 9 years experience lecturing public law, human rights, and law of trust at the tertiary level, and possesses significant legal experience in land law, conveyancing, and contract law, and has contributed to the legal services units across various public bodies. She is passionate about legal education and raising the legal awareness of Jamaicans with the aim of increasing the knowledge of their rights and responsibilities and how they can access justice. Fellow justices, help me welcome Ms. Wedderburn to our platform.
Good evening, everyone. Good evening, justices. It is quite a pleasure to be here, and I feel very welcome here. And I am very encouraged by the numbers, because that means that you are very interested in what I have to say this evening. And so if you will allow me, I am about to share my screen. I'm going to do a brief presentation on expungement, and I'm going to ask you, I know that sometimes when certain things are said, it prompts a lot of questions, so persons may be eager to ask questions, but I'm going to ask that questions be held until the end. And once the presentation is over, I will take all questions, all right, and make every effort to answer them as fulsome as I possibly can. All right. So, okay, here it is. Is everyone seeing my screen?
Yes.
All right.
Yes, ma'am. Yes.
All right, let me.
Oh, yes, I am.
All right, great. So everyone is seeing the screen, so I can begin. All right, so as I said previously, we're going to talk a little bit about expungement. In particular, we're going to look at the amendments to the Criminal Records Rehabilitation of Offenders Act. And this is the act that deals with expungement. All right, so we're going to go into some basic terms, and we're going to look at what the act initially provided, and then we're going to be looking at some of the amendments. All right, so what is expungement? So basically, as you know, when we talk about expungement, we're talking about having your conviction removed from your criminal record after a specific period of time has elapsed, particularly after a period prescribed by the legislation has elapsed. And we're going to look at the period depending on the length of the sentence that was served. All right. So it's removing the criminal record, removing the conviction from the criminal record after a specific period of time has elapsed and after certain requirements have been met. So as I said before, the statute which authorizes this activity is the Criminal Records Rehabilitation of Offenders Act 1988. But in February of 2026, the Parliament of Jamaica passed an amendment to this act in the form of the Criminal Records Rehabilitation of Offenders Amendment Act. And so there are some new provisions in this act, and the purpose of these provisions is really to give offenders a meaningful second chance. So there was some expansion to the provisions in the previous legislation. All right. And of note, both laws must be read together. All right. So it did not repeal the original act, only in sections. So the Criminal Records Rehabilitation of Offenders Act, so the initial act sets out a two-stage process in treating with the criminal records of individuals. All right. So the first stage, it allows for a person convicted of an offense to be treated as rehabilitated once a certain time, a prescribed time has passed. Now, this time is prescribed by law. And once that time has passed and the person has not reoffended, the conviction is treated as spent. And we will look at what a spent conviction is further down in the presentation. Now, once the conviction is spent, the second stage permits the rehabilitated person to apply to the Criminal Records Rehabilitation of Offenders Board to have the spent conviction expunged from his or her criminal record. So that means he would have a clean record. All right.
Book is in class, please stand and introduce yourself.
Pardon me?
I don't think that was for you. I'm gonna have to somebody.
Okay.
The mic is open.
Okay, all right. And reminding us to leave the questions for the end. All right. So the Criminal Records Rehabilitation of Offenders Act. We went through that already. All right. So the two-stage process ensures that individuals who have been rehabilitated are not prevented from accessing certain things like employment, housing, education. They're not prevented from traveling and from residing overseas or from accessing certain benefits that this criminal conviction, their criminal record, could reasonably bar them from enjoying. All right. Now, what offenses are eligible for expungement? Offenses where the sentence does not include a term of imprisonment. So that's one. So where you did not serve a term of imprisonment, you're eligible for expungement. Or where the term of imprisonment does not exceed 10 years. All right. So those two categories of persons, of offenders or rehabilitated persons, let's call them rehabilitated persons, are eligible for expungement. All right. Now, prior to the amendment in 2026, prior to February, the board could not consider applications where the sentence imposed was for a term of imprisonment that exceeded 5 years. So you recognize that there has been an expansion. All right. So if you serve a term 10 years or less, providing that it was not murder or treason or any offense under the third schedule of the act, then you are eligible for expungement. All right. Now, that's for offenses or rehabilitated persons who committed offenses locally. Offenses committed in another jurisdiction, regardless of whether the offense is one that is listed in the third schedule, these persons are eligible for expungement. So persons who in Jamaica who committed offenses that are listed in the third schedule of the act, provide for offenses that are considered so egregious that they are not expungible, right? Expungement will not be considered. However, when persons commit those acts in another jurisdiction, they can make an application. Now, we're not saying that their record will be expunged, but they can make an application for expungement. And persons may be wondering, why did we have this distinction? And the reason is some of the offenses under our third schedule may be expungible offenses in another jurisdiction. And there may be instances where their record was expunged in the other jurisdiction. However, because the record, the offense was shared with us here in Jamaica, it's still on our on their criminal record here. And so while it is expunged in that jurisdiction, we still have a cap or a bar here. And we're not saying that we're going to expunge automatically once it's expunged in that jurisdiction. But what we're saying is that we will at least have them make an application to the board so that the board can examine it. All right. So we spoke previously about a rehabilitation period. All right. So the rehabilitation period in the legislation is determined based on the age you were when the offense was committed. So persons 18 years and older at the time the offense was committed, 3 years, their rehabilitation period is 3 years, where the sentence does not include a term of imprisonment. So if they didn't serve a term of imprisonment, they would have to have a rehabilitation period of 3 years prior to being able to apply to the board for expungement. All right. 5 years if the term of imprisonment does not exceed 6 months. 7 years if the term of imprisonment exceeds 6 months but does not exceed 36 months. 10 years if the term of imprisonment exceeds 36 months but does not exceed 5 years. And 15 years if the term of imprisonment exceeds 5 years but does not exceed 10 years. All right. So they would have had to serve this rehabilitation period prior to applying for expungement. And this is for persons 18 years and older. Now, persons under 18 years old, at the time the offense was committed, their rehabilitation period is 18 months, where the sentence does not include a term of imprisonment, 30 months if the term of imprisonment does not exceed 6 months, 42 months if the term of imprisonment exceeds 6 months but does not exceed 36 months, 5 years if the term of imprisonment exceeds 36 months but does not exceed 5 years, and 8 years if the term of imprisonment exceeds 5 years but does not exceed 10 years. Now, you recognize that where persons committed offenses under 18 years, the rehabilitation period is a shorter period. And this is because considerations were given for the age and stage of that person's life, and the fact that rehabilitation is more likely the younger the offender. All right. If a person fails to comply with any condition of his sentence, he shall not be treated as a rehabilitated person. So in the period, the person must have complied with every condition of his sentence. All right. If his sentence is not spent, if he did not do all the conditions of his sentence, if he didn't perform all the conditions, he will not be considered rehabilitated, regardless of the lapsing time. The rehabilitation period commences from the date of the termination of the sentence. So that's when you start counting the years from the date the sentence was terminated, right? Now, where the sentence applied is a suspended sentence. The rehabilitation period commences on the date on which the sentence would have terminated, had the court not granted a suspended sentence. All right. Now, where a person commits 2 or more offenses and serves a concurrent or consecutive sentence, the rehabilitation period in respect of each offense does not commence until the termination of all the sentences. So all the sentences would have had to been served, terminated prior to the rehabilitation period commencing. All right. And if the sentence is suspended, the rehabilitation period begins to count at the time the sentence would have been terminated had it not been a suspended sentence. All right. So a conviction is treated as a spent conviction. So we're going back to what a spent conviction is, because we said that if a person is considered rehabilitated, they're a rehabilitated person, so they have served the time and a certain period has elapsed since their sentence terminated, then they have not reoffended, then they are considered rehabilitated and their conviction is spent. So a conviction is treated as spent where the appropriate rehabilitation period, as provided by the Act, which we just went through, has expired. The person is considered rehabilitated and is not required to disclose the conviction in particular circumstances. So once your conviction is spent, you are not required to disclose your conviction. Now note that there is what would we say now? It's not in all circumstances, it is in particular circumstances. All right. So notwithstanding the criminal record of the person, notwithstanding all of that, the criminal record of the person is not automatically cleared. So your conviction is spent. It is spent because you have served your sentence. It is spent because the prescribed period, rehabilitation period, has elapsed. Notwithstanding that, your record is not cleared automatically. The offender or the rehabilitated person must make an application to the Criminal Records Rehabilitation of Offenders Board through the Ministry of Justice and Constitutional Affairs in order to have his criminal record clean. All right? So in order to have that conviction removed from the criminal record. And there are certain circumstances where a person may be required to disclose their conviction even though the conviction is spent. All right? So the general rule is that once there's a spent conviction, the person is not required to disclose. However, there are circumstances as provided by the legislation where persons may be required to disclose. All right? So if requested, a person must disclose particulars of his spent conviction to duly authorized persons. 1, when seeking membership of a professional body specified in Part 1 of the first schedule. So if you are seeking to become an attorney, an accountant, those professions that have professional bodies that check your records or want to ensure that you are in good standing before accepting you to the profession, they may ask you to disclose, and you are required to disclose. All right. Now, when seeking appointment to any office of employment, which would be specified in Part 2 of the first schedule, or when seeking to engage in any type of business specified in Part 3 of the first schedule. So these employments would include government official services, and these business types would include things that particularly have to do with money transactions and that kind of thing. All right. So here is the first schedule, Part 1, 2, and 3. So when you look at it, you will see that for the professionals, if you're an attorney at law, chartered accountant, dentist, medical practitioner, you may be required to disclose. For employment, if you're civil servant, military service, judicial service, you may be required to disclose. For businesses, if you are dealing in bonds, stockbroking, if you are a firearms dealer, you may be required to disclose, all right, even though your conviction was spent, all right? Now, when you have served your sentence and the rehabilitation period has passed, you are eligible, provided that you are within the category of eligible persons. So you did not serve a sentence, or you served a sentence for 10 years or less, and the offense that you committed is not listed in the third schedule. Then, of course, you can make an application to the board to have your record expunged. So prior to the amendment, the board was not guided by a list of factors to consider in its assessment of applications for expungement. The list has now been included as it is viewed that it will assist the board in determining the worthiness of an applicant for expungement, free from extemporaneous factors. So what are the things that the board will consider? When the application is made, the board will consider the nature and gravity of the offense that was committed, the findings of a social inquiry and psychological evaluation, completion of rehabilitation or resocialization programs, evidence of remorse or accountability, participation in restorative justice, restitution to the victims where relevant, the age of the offender at the time he committed the offense, whether international obligations limit or bar expungement, whether expungement would affect any other law, and whether the applicant has reoffended. Now, these considerations of the board, what the board is trying to ensure is that the person who is before it is actually a rehabilitated person. And these things will assist the board in making that determination. So having a social inquiry, speaking to justices of the peace, having psychological evaluations, so justices of the peace that would have interacted with these persons who are members of these persons' community, social groups, that kind of thing. So we're doing a social inquiry. Did the person complete any rehabilitation program? Did they show evidence of remorse? How did they relate to the victim? Right? Was there restitution made? If restitution is possible, those things are things that are considered to determine whether or not this person is truly rehabilitated, because we don't want to be clearing the records of persons who are not truly rehabilitated. The point of the legislation is to give persons who have changed a meaningful second chance. So the first thing we have to ensure that we determine is that rehabilitation, in fact, took place. All right. So the Criminal Records Rehabilitation of Offenders Amendment Act increases the membership of the board, providing that it shall consist of no less than 7 or more than 9 persons. This increase, it is hoped, will facilitate a greater cross-section of board representation. Additionally, the increase in the remit of the board will result in an increase in the number of applications received by the board. So if you recognize, we have moved the eligibility for application from persons who served a sentence 5 years or less to 10 years. And so it is anticipated that there's going to be an influx of applications. And so it was deemed necessary to increase the number of persons on the board to ensure that they can actually deal with the applications in a timely manner. All right. So it will be necessary to expand the membership so as to adequately tackle the volume of applications placed before it. Now, suppose an offended person applies to the board and their application is rejected. So where an application for expungement has been rejected, the applicant may reapply after 2 years from the date of the rejection. Now, of course, if you are going to reapply after 2 years, it would mean that something materially changed. So either you participated in some restorative justice program or something that would tip the board to determine that you are truly rehabilitated. All right. So you can reapply after 2 years from the date of the rejection. Now, where an applicant reapplies to the board and his application is again rejected, the applicant may appeal to the Minister of Justice and Constitutional Affairs within 60 days from the date of the rejection. So 60 days after the rejection, they can make an application to the minister. Now, the minister will then review all the circumstances of the case. If the minister finds that the board failed to consider something, and if they had considered it, can we mute our mics, please? Can we mute our mics, please? So the minister reviews all the circumstances of the case. And if he finds that the board failed to consider any matter where such consideration would amount to sufficient reason to grant the application for expungement, the minister must direct that the case be remitted to the board. So if the minister, upon examination of the entire circumstances surrounding the case, determined that there's something that the board missed, there's something that the board did not consider, and if the board had considered this, the likelihood of them granting the expungement would be great. Then the minister will remit the case to the board, and the board must reconsider. However, where the minister is satisfied that due consideration was given to the application, so the board considered the application, there is nothing that would have made the board nothing that the board missed that would have made them grant the application had they considered it, then the minister will reject the application on appeal. Now, if the minister finds that the decision of the board is unjust or perverse, he will allow the appeal. So in circumstances where the minister thinks that, or finds that, I don't want to use the word thinks, finds that the board was unjust or perverse, he will allow the appeal. Now, in those circumstances, the case is not sent back to the board, but the minister will reverse the decision of the board. The minister's decision in these circumstances is final. All right. Now, there is a possibility for automatic expungement, which means that an application to the board is not necessary. So there are provisions for individuals to automatically benefit from expungement without being required to make an application to the board. So the Criminal Records Rehabilitation of Offenders Amendment Act provides for automatic expungement of non-custodial convictions where the sentence was imposed and the penalty satisfied before, January 1, 2005, and where the person was not convicted of any other offense. Now, this offers an expansion to the provisions for automatic expungement, which was previously only afforded to offenses under Section 7C of the Dangerous Drugs Act, where the fine imposed does not exceed $1,000. So automatic expungement is available to persons who did not serve any term of imprisonment and the sentence was imposed prior to January 1, 2005. So the third schedule contains offenses considered so egregious they warrant an automatic rejection of an application for expungement. So these offenses were removed from the third schedule. So these offenses that were removed, Section 3 of the Malicious Injuries to Property Act, unlawfully and maliciously setting fire to a dwelling house, Section 37 of the Larceny Act, robbery, Section 42A of the Larceny Act, extortion, Sections 3, 5, 6, 7, 7A, 8, 8A, 9, 11, and 21A of the Dangerous Drugs Act. What this means for dangerous drugs is that these offenses, all the offenses under this legislation, are eligible for expungement. So the board is now empowered to consider applications for expungement of offenses listed in the third schedule, where these offenses were committed in another jurisdiction. In empowering the board to consider the expungement of these offenses, it was considered that restriction may result in undue hardship for returning Jamaicans, particularly those from jurisdictions where great confidence cannot be placed in their criminal justice system, nor the integrity of their convictions. Additionally, there is a possibility that the criminal record of these offenders may be expunged in those jurisdictions, but remain on record in Jamaica. So it must be pointed out that although persons who have committed offenses under the third schedule in another jurisdiction, although they're eligible to apply, it doesn't mean that they will always get expungement. The board will look at the same considerations in order to determine whether these persons are truly rehabilitated. But of course, the reason for doing this is because, one, sometimes they are coming from jurisdictions where we have no confidence in their criminal justice system. And sometimes the jurisdiction that they're coming from, based on their expungement regime, that record is expunged or eligible for expungement in that jurisdiction. And it was thought that it would be undue hardship if it is expunged in those jurisdictions, but not in ours. All right. So how do you apply for expungement? And I think that justices are particularly interested in this, because this is where you also get to guide persons within your communities who may want to apply for expungement through the process. All right. So the applicant is required to complete and sign 2 application forms. Application forms are available online at moj.gov.jm. Also, the person can go to the service desk at the Ministry of Justice and Constitutional Affairs at 61 Constant Spring Road and pick up the application forms there. The application form should include the name, address, contact number for 2 referees who are not family members. So they need references, but the references cannot be their family members. It must include the name, address, and contact number for 2 persons authorized by the applicant to act and or make inquiries on the applicant's behalf. When the application form is being turned in, it should be accompanied by fingerprint impressions of the applicant. They must pay the $3,000 application fee at the tax office, all right, and walk with that receipt. 2 letters of recommendation from the referees listed in the application addressed to the Criminal Records Rehabilitation of Offenders Board. So the references must give them recommendation letters. A certified or notarized copy of the applicant's birth certificate. And if the applicant changed their name at any time, their name changing document, all right? Or a certified or notarized copy of a valid government issued photo identification. Example, their passport, driver's license, voter ID, or national identification card. Any other supporting documents relevant to the application, example, their court records. Important information, documents submitted must be original. So it must be an original document and it must contain all the required information. So any document that is sent with missing or incorrect information, including any name discrepancy, inconsistent spelling. So if you have a birth certificate with one spelling and then your national ID have another spelling, it will not be accepted. All right. So where the name on the application differs from the identification provided, additional identification may be required. All right. Fingerprint impressions can be taken at the Criminal Records Office, which is at 56 Duke Street, Kingston, Summit Police Station in St. James, Maypen Police Station in Clarendon, or Area 2 Police Headquarters, Pompano Bay, St. Mary. Now, letters of recommendation from the referees must be legible, especially in circumstances where the referees write it, handwrite it. It must be dated, it must be signed. It must include a return address and state the following: how long the referee has known the applicant, how the applicant conducts himself or herself, whether the referee recommends that the applicant's convictions be expunged. Now, these things are important. And if something is left out, then of course, that may defeat the application. All right? Referees must be persons, of course, of unquestionable integrity, such as ministers of religion, justices of the peace, principals, teachers, attorneys, medical practitioners, or senior police officers. And I know that some of you on the platform fit in more than one of these categories. All right, so the process. Step one, when the completed application form is received and all supporting documents, a police report is requested from the Criminal Records Office. Step two, upon receipt of the police report, the Criminal Records Rehabilitation of Offenders Board will review the application and make a decision. And of course, the considerations that were listed earlier are things that they will consider when the review is being done. The applicant will then be advised of the decision in writing. If an applicant requires a police record after his criminal record has been expunged, he must pay for this service, which is provided by the Criminal Records Office. All right, here endeth, well, not quite, contact information. So for more information on expungement, you can contact us at 888-JUSTICE or connect with us via WhatsApp chat at 876-851-3287. And of course, all the information about the procedure that I outlined earlier is listed at moj.gov.jm/expungement criminal records, criminal records. Should you require this information, I can share it with the group and it be disseminated. All right. So I am now opening the floor for your questions and I will make every attempt to answer them.
Thank you, Madam. The floor is now open. Cheryl White and then say Kesslyn Gilbert Stoney.
Good afternoon, everyone.
Good afternoon.
After an applicant application is approved by the Minister for Expungement, how long after can he apply to the police record to show a difference on the police record? How long after that?
All right. So when the written decision has been sent, if he needs to make an application, the board can make that application for him. All right. So that is something that is determined by the board and how speedily they make the application. But I think once he gets that written record, that written decision, that application can be made.
Okay. All right. Thank you.
And just to say, it's not him and her, or he or she.
Oh, I apologize for that. I'm using he in the context of male and female.
Because females get arrested too.
No, man, as a student of English, you know that he means him and her when you're speaking generally. So we're not being biased. Yes, go ahead.
Thank you. Thank you for the presentation. I believe I have one clarification and a question with respect to the persons that could be eligible for automatic expungement. How does that work? Yes. Yeah, expungement. Could you explain to me how that would work in terms of practically? Yeah, who is doing that automatic and how is it going to work practically? That's one question. Go ahead.
Okay, so when we say automatic expungement, what we're saying is that it doesn't have to come to the board. All right, so if they find that that is on their criminal record, they can ask for it to be removed, because once they did not serve a sentence, all right, and so it's a non-custodial sentence, and the sentence was imposed prior to January 1, 2005, then that should not be on their record at all, in fact. So if they find it on their record, they can go to the criminal records office and have that removed.
Okay, so just simply going to the criminal records
Right,
office, so it's not to
it
the
doesn't
board.
have to come to the board at all, is what we're saying. So an application to the board is not necessary in that circumstance.
All right, great, thanks. The other question, you, in the earlier part of the presentation or clarification, you mentioned about rehabilitated person. This person is considered rehabilitated, having had their conviction spent, it terminated, and they served this additional time. But you also went on to say that there is a listing of consideration that is now available to the board, which appears, and I understand the thing about whether you're truly rehabilitated, but because you had put so much emphasis on those two conditions of who is now considered a rehabilitated person, and now you're saying there are additional conditions that the board can look at and maybe moved or maybe become compulsory almost, not all the conditions clearly. I'm just wondering how both of them can be reconciled. You got your, using the custodian sentence one, of course, you got your custodian sentence, it's terminated, you got the number of years afterwards, you spent it, you are now integrated in society, whatnot, but then you're saying, having established that you did the sentence, having established that the time has elapsed, you're saying I need to establish some other factors based on the listing?
Right. So let's not look at it in that way. All right. So let us look at it that, so what I said is that it's a two-stage process, right? So stage one, the first stage is that the person who was convicted, right, is treated as a rehabilitated person because after they have served their sentence, a particular time has elapsed. That time prescribed by law, by the statute, has elapsed. All right. So in those, and they have not reoffended. So that's just the criteria. You serve your sentence, it terminated, a set number of years has elapsed, and you have not reoffended. That's criteria one. So you are now considered a rehabilitated person, and your conviction is now spent. Now, at that first stage, what the benefit that you have at that first stage is that in certain circumstances, you don't have to disclose at all that you were convicted, right? However, if somebody goes and pulls up your criminal record, it is not clean. It will still have the conviction on it. So that person, in order to have that conviction removed from their criminal record, must make an application to the board. Now, what we're trying to ensure is that this person is in fact rehabilitated, because you can have somebody who was convicted who during the period, the rehabilitation period, did not reoffend, but they're still not a rehabilitated person. Because reoffending the circumstance is that they were caught. So, or they were charged and convicted, I would say. So you may have persons in communities that are not exhibiting any indication of rehabilitation. And yes, they have not been brought again before the justice system, but anyone in the community interacting with them would not consider them a rehabilitated person. So it is for the board to know, investigate. So that's why they're doing these social inquiries. That's why they're doing these psychological profile. That is why they're getting references to see, the behavior of this person during this time. That's why they're looking at, okay, so how did this person, was any restitution made? Did this person take become accountable for the offense? You know, that kind of thing. Is this person truly rehabilitated? And it's on that basis that the record is cleared, and only on that basis. All right, because there is a distinction between somebody who has just been you know, not convicted again and the time has elapsed, and somebody who has been truly rehabilitated. And that is what the board is trying to determine. All right, I hope that you understand, or you can see the distinction between stage 1 and stage 2.
Thank you for your comments. I appreciate it.
All right.
Okay.
So I think next up we have I think Donovan Wignall, and then George Brown, then Francisca Price, then Richard Cole. I think it's in that order.
All right. Thank you, Chair. Thank you very much for a very informative presentation, Ms. Wedderburn.
You're welcome.
I would like to know what is our role, or what are our roles as Justice of the Peace in the process of expungement. It might have been said, but I didn't hear.
All right, so the first role that you have is to know about expungement so that you can guide those in your communities that would want to make applications for expungement. All right, so you would be able to say to them, okay, if you are going to make an application for expungement, this is what you are required to do. In addition to that, you can serve as a reference in their application for expungement, because that is one of the significant things that are examined, what the referees say, because a reference is the person who would be in the community with these persons, who would be the ones who form a part of these persons' social groups, and would be able to say definitively that based on my interaction with this person and based on the interaction with the person in the community and with other community members and with the society at large, I can say that this person is truly rehabilitated. And so that is something that justices of the peace, those that serve their communities. I mean, I know that especially in rural Jamaica, the justices of the peace know all of the people in the community. They're in and out, everything about them. And because of that, they are the greatest witness to the character of those persons. So one is a role to guide, and one is to act as reference.
All right, thank you very much.
Yes.
Good afternoon, everyone. Ms. Wedderburn.
Yes.
My question is, what happens to a person who has been found guilty in a lay magistrate court for an offense? Does that person is entitled to the same amount of time with regards to the expungement of their records?
All right. So I cannot answer that question without just making reference to what the Act says, right? So what the Act says, so regardless of where you were convicted, right, the Act is saying that you are eligible for expungement if you did not serve a term of imprisonment, 1, or 2, if you served a term of imprisonment and that term was 10 years or less, and the offense that you committed does not fall in the offenses under the 3rd schedule. So once you fall into that category, regardless of where you were convicted, once you fall into that category, then you are eligible for expungement.
Thank you very much, Ms. Wedderburn.
Okay.
Good evening, everyone. Excellent presentation, Ms. Wedderburn. My question is, if someone lives abroad, can their records be expunged in Jamaica? Or they have to come down and do it themselves? What I mean to ask, can somebody do it for them? Go through the process for them?
So there is a provision when the application is being made, that a person can actually list persons who can carry out the application for them. So they made the application, and in the application, they name persons who can actually carry out the application, get information, all of that for them. But of course, they would have to present the requisite information, address, identification, all of that of the person, so that when information is being given, the board knows that they're giving it to the correct persons.
Thank you very much.
Sure, cool.
Ms. Wedderburn, thank you for your presentation. Very informative. 2 questions. If someone came to me and said, right, I want to have my records expunged, and they ask the question, well, how long is it going to take? Typically. Yes. I'm sure that's a question that will be asked. So that's my first question. The second is, in looking at the 3rd schedule, I don't see anything about murder or rape. So is that a complete list of criminal offenses that have been removed or are
no,
not?
murder and rape. Unfortunately, I don't have the 3rd schedule at hand, but murder is definitely
absolutely
on it.
So these were added.
Yeah.
Okay.
So,
okay.
so those are on it. With respect to the time, I want to say a year, but there are certain circumstances that may cause the application to go
Take
beyond
longer than that.
Yes.
Right.
But usually it is dealt with within a year. One of the things is that getting information from other bodies and reports sometimes take a little longer than the board would like. And these are some of the things that cause the delay.
So, okay, so from the time of applying to the board meeting and making the decision, that is typically how long?
A year.
Oh, so that's the process from application to board decision is a year.
Is a year.
Okay.
Yes.
Okay. All right. Thank you.
Yes.
Good afternoon, neighbors. Ms. Wedderburn, thanks again for your presentation. Robert Brown here. Okay, so you did mention about persons under 18. I don't think I remember what was the respective application of time. Probably you could just repeat that for me as just one of my queries here.
All right, so persons who are under 18 years, if they served a term, if they did not serve a term of imprisonment, the rehabilitation period is 18 months. It's 30 months if the term of imprisonment does not exceed 6 months. It's 42 months if the term of imprisonment exceeds 6 months, but does not exceed 36 months. It's 5 years if the term of imprisonment exceeds 36 months, but does not exceed 5 years. And it's 8 years if the term of imprisonment exceeds 5 years, but does not exceed 10 years. I think what probably would be helpful if I send some notes, because sometimes the legislations are a little tedious to read. Our legislation can be a little difficult in language. So what I can do, is send some notes and it be disseminated.
Okay,
so
that
that
would be
you
great.
always have it at hand.
Yes, that would be great. I appreciate it, because I mean, in the event that as a JP and having to deal with someone inquiring, we would like to be able to have information that could, assist in that regards. And in following up with that, I'm not certain if there are any listing of any rehabilitating entities, because what if someone would come to us as JP and inquiring as to probably where they could go to even start the process of a rehabilitation for this consideration? I don't think I'm not knowledgeable of where I could probably reference them to in regarding to this process.
Well, there are restorative justice proceedings that are done through the Ministry of Justice, and of course, they can avail themselves of those services. And typically, counseling places, there are several places that offer counseling services in Jamaica, and they can avail themselves of those things as well. So rehabilitation with respect to getting back in good graces with your community, depending on the offense that was committed, something like that is something that the Ministry of Justice could possibly facilitate. But rehabilitation with respect to dealing with your own trauma, your own issues, that's something that a counselor could also facilitate. And once you go through those counseling programs, once you go through rehabilitation with the Ministry of Justice, those reports would be available and can be presented to the board. Psychological examinations are also available. You can have persons do psychological examinations, and those reports could also be presented to the board.
Okay, thank you.
Good evening, everyone. Ms. Wedderburn, I had a question similar to Mr. Brown's. However, I wanted to ask, suppose the person under 18 years old, supposing they were tried as an adult, is it the same period that applies to them?
Yes, because once they were 18 years, under 18 years at the time the offense was committed. So it's not how they were tried, it's the age that they were once the offense was committed.
Okay, all right, thank you.
Yes.
I have a question. Good evening, everyone. Just out of curiosity, is the applicant required to meet before the board, and is the applicant interviewed during the application review before?
Right. As far as I know, it is a paper-based application. I don't know of instances where the applicant is asked to come and be interviewed by the board. As far as I know, it's a paper-based application.
Great, thank you.
So we're going to take two from the chat. Tishan, and then we'll come back to you, Gonzalez. So there are some in the chat. I'm not sure if you're seeing them, Ms. Wedderburn. Carly, can someone assist me here? I'm going through.
So Kishan is asking, Chairman, is fingerprint impression the same as a police record in this case?
No.
That sounds confusing. What does it mean by a fingerprint impression?
So the person must get their fingerprint taken, yes. Their fingerprint taken.
Yes. If the person is online, they can expound on the question. Right, Ms. Wedderburn?
Yeah.
Good afternoon. Good night, actually. This is Kishan. So,
yes.
So I was wondering, as you explained just now, so as we all know, you take your fingerprint to get a police record. You're saying that it's not a police record that is needed now, but just the 10 prints?
Yes.
So how is the 10 prints provided to the board?
So they go
when you go down to CRO?
So as far as I know, fingerprints, I said it, there are some places where fingerprint impressions are taken, and you go to those places, get your fingerprint impression taken, and take it to the board, or it is sent to the board.
Okay, that's what I just was confused as to whether or not it was a police report or just the 10 prints. That's all I want.
No, the 10 prints. Yes.
Thank you.
Thank you, Kishan.
Yeah,
and there was another question in the chat.
Jeffrey Thompson, he says, so if you are completing a form that requires information regarding your criminal record, but it is not among the list of compulsory disclosure, is it honest or reasonable to put that you have no criminal record after your criminal record is expunged?
All right, so that's a question that everybody keeps asking. And the issue is, what does the thing actually ask? Because if the question asks you for a criminal record, you can present a clean criminal record. But if the question says, have you ever been convicted? You cannot say no. I mean, we had a presentation at the embassy, and this was one of the questions that they were asking. Can the person say no? And we're saying, well, we're not encouraging persons to say no, because of course, honesty is something that is necessary. What we are saying is that if you are asked to provide a criminal record, then your criminal record will be clean. But if it is that somebody says, hey, were you ever convicted? Which is what a lot of these, particularly the embassy forms, actually ask. Persons say no, and the truth is, if you say no and present a criminal record, the criminal record will be clean, and if they accept that, then it is no. However, it is factual that places have ways of digging and finding out that there was a record prior. So it happens. Sometimes they go to the courts, and court did not burn the record. The court don't burn their record. So the record is there at the courts. And so persons have been denied, say, visas in circumstances like those. And that is something that we, at the ministry, we have actually been in discussion with, because it actually defeats some of the things that we are attempting to accomplish, particularly in relation to travel. But the thing is, we're going to have to figure out what procedures we can put in place and how we can prevent this access to information outside of the criminal record in order to actually give persons a complete and free second chance. But at this juncture, it's difficult for me to say to you, say no. Because if they ask if you've ever been convicted, I cannot advise somebody to say no.
What I know some of them are doing
They
now,
can refuse to disclose what you've been convicted for, and they can't force you. But when they ask you, have you been convicted?
Ms. Wedderburn, what some of them have been doing now, you know,
Mhm.
especially when you're applying to become JP, they say that they have not been convicted in Jamaica. So they're answering no. All right, so there's a question here, and I think I can answer it. Thank you for a very insightful presentation. Can a justice support a co-worker application for expungement? Having worked in relationship with a person for a number of years, though the justice doesn't reside in individual community. Yes, if you know the person.
Yeah.
It's not because you live near the person, you know, it's that you know the person, and you know, that is what.
Yeah, that's what's necessary.
Yes.
Yeah, that you know the person, that you interact with the person, and you're certain about, you know, the person's behavior, how the person's now operates. Is the person actually rehabilitated? And once you are aware of that, once you are assured of that, then you'd be a great referee.
Gwyneth, I'm coming to you. This last one, great. My question is, what should an individual do after they got an expungement and a clean police record, but 6 years down the road apply for a record and a conviction is on it?
That one kind of stumped me.
Yeah, yes, that is. Yeah, because, yeah, no, so what should an individual do after they got an expungement, receive a clean police record, but 6 years down the road applied for a police record and a conviction is on it? Boy, I see that one bold you. That we call a Google. Google, Miss Wedderburn, Google.
I would, that is something that should not happen.
Yes.
And that is something that should be taken up with the office, because that should never be the case.
So what I would advise the person is to go back to the criminal records office and make some inquiries of what is happening and present to them their certificate that they got some time ago before, and to say that their record was
The record was
expunged.
expunged. Yeah,
Mhm.
that shouldn't happen. And you
Yes.
got especially if you got a clean record before, how
Yes.
would you then get a record that shows the conviction?
Miss Wedderburn, sorry to interrupt, but I know of an incident like that where it happened. The person was getting their firearm renewed, and it about 5 years before their record was expunged. But the firearm place still have it on their system that he still has a criminal record. So he has to go through a lot of process back to the ministry and down to the criminal record for them to get it off the system. That's the way he could get his firearm renewed.
Oh, so all right, hold on. So you are saying that FLA had it before it was expunged, right?
Well, I'm not sure if they had it before, but he got his firearm. It's when he went for renewal. Couple years after having it for so many years, it was on the system. I don't know how it happened, but he got his expungement and he had to walk through the process to get it off again.
I'm not sure.
I think that was just some administrative error.
Yes.
And
yes, I believe so.
Unfortunately, that is something that he would have to do. He would have to walk through the process again.
Because even the court had the record that because the court had to supply the record and all of that. And he was saying that why is it that all of this was cleared and now they're saying that I can't renew my firearm license because the record is still there. So he had to do a lot of legwork to get it off.
Yeah, that's quite unfortunate because that should not have happened administratively.
So Chairman.
All right, thank you.
Question have been answered. He has a visa application, but Miss Wedderburn would have just answered it a while ago. So you may go ahead with Miss.
All right, Gwyneth Gonzalez.
Hi, good evening. Thank you
evening.
For allowing me to ask my question, which I think probably was maybe slightly dealt with. But my question is, based on everything that you have said, if the person filled all the criteria, did everything, you said that the expungement is to give persons a second chance. And so you should not be discriminated from a job or anything like that. My question is there anything that will be put in place for the employers, or how should I put it? For argument's sake, I had an offense, got through and everything, and now I apply for a job, and I am not given the job because of all of this, and I've gotten the expungement and everything. I'm saying that, is there something gonna put in place that there's no discrimination against persons who have been expunged so that they can get a fair chance in society to get a job, to get a whatever? How are we going to sensitize the work world so that persons that fall into this category are not discriminated?
Well, the legislation does provide that the person, once their record has been expunged, that your employer, save in the categories that were mentioned, should not utilize this your conviction against you to withhold a job from you or anything like that. So it should not happen.
And if it does, who do you go to? How can you get?
Well, if it does happen, it is an offense, right? Of course, there are circumstances, and we're speaking very practically here. So there are circumstances where they may refuse you the position, but they will not say that that is the reason that you were refused. You know that, right?
Right.
So there are ways that employers have to circumvent these things. I think that what is the most important thing with respect to this legislation is that when you are interfacing with your employer and or any other entity and they say, okay, we need a criminal record, when you present the criminal record, it is clean. And so there is no need for them to go behind the curtains, to lift the veil of that clean criminal record that you are presenting to them. And I think that is what is important. A lot of times persons may do that, and that is something that ought not to happen, particularly for Jamaicans with respect to the travel with the embassy. They have other laws that allow them to be able to do that, and that is something that we probably need to deal with. But with respect to Jamaicans, we ought not to go beyond what is presented before us with respect to a clean criminal record. We ought not to do that. And if it is that we have done it, if it is that we have refused somebody employment and their criminal record is expunged, or we have said to them, okay, you need to disclose what your conviction is, then the law actually provides that that is an offense. It ought not to happen. And it would be treated as any other offense. But everything, of course, boils down to what is proven or what is able to be proved in court.
Okay.
And I'm going to add that for persons, especially those applying for your visa, please, if you did have a criminal record, please explain and tell them that yes. Don't hide it, because they will find out. And they will find it. And then that time now, you're not going to be blacklisted just now for years to come. So please. Clive Davis.
Somebody was asking in the chat before you continue, when the individual is expunged, do they receive a document? Yes, they get their certificate.
And that's like their passport that they walk around with.
That is what they used to make an application, to have their record removed. So the board actually provides something in writing.
Okay, Madam Presenter and colleagues, good evening. I really appreciate your presentation, and I think it's pretty clear to us, our roles and responsibilities going forward. But my concern, though, is that what is the link between the legal opinion and the legal guidance that you've given and the operational side? And I'll tell you why. In a few weeks, we're going to have one of these big to-do at the national arena dealing with traffic tickets. We've had it before. And you get a traffic ticket, and although you pay at the tax office, it's not recorded at the courthouse, or you pay at the courthouse and it's not recorded at the tax office, and the police system does not pick it up. What has happened since, or what is different about this system that will cause me or anybody else to get an expungement and all systems find or have it recorded as an expungement?
That is something that the different government entities would have to come together and formulate. That is something that they would have to be sharing their systems, or the government of Jamaica would have to have one system that captures all of that information. That is not something that I have the answer to. I don't know how to fix that, save and except it is policy driven, and one system is used to capture the entire justice framework from charge to conviction to the record to expungement and all of that. Unless it is one integrated system, these administrative errors will continue.
So, Madam, may I ask then, please, if you allow me, one, do you know of any active process or, program in place now to deal with that matter? And if not, what is it that we need to do to fix this? there's too much disconnect, that's my opinion, in the government of Jamaica systems. Too much disconnect. And so I would not want somebody to have gotten an expungement and 20 years later they are arrested because they did not turn up for their last hearing when there was not supposed to be a hearing.
Well, they
Do you
wouldn't
know
have been
any
granted an
program?
expungement if they had a hearing, because the first thing
Well,
would have to happen if an expungement comes into play is that they
Madam,
would have been convicted, they would have been sentenced, they would have served their sentence. A certain period, as prescribed by law, would have elapsed after their sentence was served. They're rehabilitated, then they make an application. So that would not come into play. What would come into play is what one of the justices described, where somebody may go back for a record and find that the conviction is present on their record, even though their record was clean previously. And those things are administrative in nature. And unfortunately, administrative errors do occur. And like I said before, there is no fix, save and accept, because there are human errors, but there's no fix. The cleanest fix would be that if there is one integrated system. And I'm not certain if that is something that, while I'm sure these things have been contemplated, I don't know if an integrated system is on the horizon as yet, where this is concerned.
So I can add to some of that, Ms. Wedderburn. So in my former life, I was with a system where the traffic ticketing is concerned. So the police and the tax office, they are linked, because when you pay your ticket, it goes to Inland Revenue, and then it goes to eGov. I know that the minister is working on a system for the courts to computerize the courts. So yes, it's something that is being worked on. Yes, it's taking some time.
But will it all be integrated? Is it that the court's records will be okay?
Well, yes, it will be integrated. Even I can tell you also, even for conviction also, I know in the future, they want to have the same system that is at the Criminal Records Office. If a judge wants to pose a sentence on you, they could make a check right there in the court to see if you have any conviction, using the same fingerprint system to see if you have any conviction or anything else like that. So it is something that is coming, and I know it is frustrating at times, but yes, it takes time. Our systems are not. They have different process. So it is not easy to integrate like elsewhere. But yes, they'll be integrated.
Okay. All right. Well, that sounds good. That sounds promising.
Yes, it is. All right. Any other questions?
Just to point out that under the needs, I think that's one of the things that they're looking at under the needs.
Yes. And I'm sure that person on the platform would have had their needs ID. But then again, it doesn't make sense. Why I say that? I went to the bank and I showed them my needs ID or the credit union, and they say, we don't take that here. And I'm saying, okay then.
That is something that needs to be discussed, Superintendent, because there was a release that went out that said that the card should be accepted wherever you present it.
Yeah.
So the bank is not adhering, and they should adhere.
Yes, I told them that I was going to make a complaint about it.
Tax administration in Jamaica ran me away with it about 2 months ago. We don't accept it. And I'm one of those guinea pig in the 100 group with my big card, but they ran me away.
But they will have to take it. They will have to end up taking it. It's just time. They will have to end up taking it.
So it's just that a number of things that we need to do, and we need to, whenever these things happen, we need to make a note of them and make the complaint. I gave you another example that I wrote on a passport size photograph for someone, just to verify the photograph. They went to the tax office. The person at the tax office told the girl that it was illegal because I need a stamp to stamp the photograph. and I'm saying, but this is my handwriting, so if I'm doing something illegal, you have the handwriting expert who say that John Brown that signed the form, he's not a JP and whatsoever. So, you know, these things we need more sensitization session, not only for us, but persons that work in these industry.
Some people take up decisions on them own too, you know. Because that don't make no sense what they just said just now. I believe she just made that up on the go as she went along.
Yeah. All
I
right.
believe that. Can I
interject?
just quickly say one thing? I believe what's happening in some of the government offices is that they don't want to check the system, because once a JP signed without a stamp and their code is there, all they have to do is go and check it. And they are lazy in doing that.
Mm-hmm. All right, so 2 more questions. Robert Brown.
All right. It's not a question really. I just trying to just find out how will the presentation be made available? Is it gonna be sent to who?
So we normally do a synopsis of the presentation, and we normally send it out just like how we send it in the email. And we will send you and do a summary of the presentation. Or if Ms. Wedderburn wants, we can do it and share in the email to you as the members of the association.
Well, I can send the presentation to Miss Novelet Green.
Yes, and she will answer it, and we will send it inside our grouping. Carlet, could you put in the chat for those of you that are not getting any email, so that you can sign up to get your email? Carlet, can you put it in the chat again for me, please?
Certainly, Chairman, will do.
Thank you, Ms.
All right, thank you.
Wedderburn. This is Novelet.
All right, so we are at the final part, and I'd like to say I have the honor of wrapping up today's session by expressing our heartfelt gratitude to Ms. Julia Wedderburn for her incredible presentation on expungement. We want to thank you for shining a light on the topic that matters so much to our community. The process of clearing a record can feel overwhelming and intimidating, but your presentation brought a massive wave of clarity and hope into the room today. You didn't just share legal facts, you showed us a real pathway to new beginning and fresh starts. Thank you for your warmth, your patience in answering our questions, and your dedication to making legal literacy accessible to everyone. A big thank you as well to everyone who joined us today and share in this space. Ms. Wedderburn, we appreciate you, your expertise, and the vital work you do. Thank you so much. And thank you very much. God bless. And
thank you. I want to thank you.
Coming up.
Pardon me?
I was telling the group to look for more presentation that is coming up.
Oh, okay. I want to say thank you all for having me, and thank you for being so attentive and receptive.
Yes. And we have Father's Day coming up. So please, ladies, remember to take care of the dads in the house, the fathers, the grandfathers. And we also have the Puppy Appeal concert that is coming up at Stella Maris. So please, members, we need your support. Thank you. God bless.
God bless you.
Thank you all.
Father's Day when it comes, Dad.
Happy Father's Day when it comes to all the father.
Thank you. Excellent.
Bye, everybody. Bye.
Bye.
Excellent presentation. Thank you, Miss Wedderburn.
Bye. Excellent presentation. Happy Father's Day when it comes. Take care, everyone. Bye.
Bye-bye.